Thank you, Mr. Chairman. Congress recently passed a bipartisan bill. Many of us up here supported it. I know I did. As part of the water infrastructure bill to allow states to lead implementation and enforcement of EPA's coal ash rule through the state-based permit program. That rule is already in effect, and it's important that the EPA move quickly on this. If you are confirmed, you're going to get right on this thing?
Yes, Senator Inhofe.
All right. Sue and settle, we all know what that is. We know that groups, maybe some of the environmentalist extremist groups, will file lawsuits and against the EPA. The EPA, instead of defending against the lawsuits, will enter into a resolution behind closed doors without any public input or participation. These settlements result in new sets of legally binding priorities and duties for the EPA that achieve the demands of special interests. Can you share your thoughts on sue and settle?
Senator, this issue came up earlier, and it's a concern because it's regulation through litigation. And anytime that there's a place for consent decrees in our litigation system, but to use a consent decree to bypass Congress, bypass the regulatory requirements that you've placed upon those agencies to engage in rulemaking through litigation is something I think should not occur.
And that's the part that did not come up earlier, and I appreciate that very much. And then lastly, the cost of regulations. As you know, the Supreme Court overturned EPA's mercury and air toxics, that's Matt's rule, in 2015 because the EPA failed to ignore the fact that the cost was $9.6 billion annually of the rule. Now, in fact, the EPA's regularly issued rules over the past 8 years that are very costly for our industries and our job creators. According to the CRS, now CRS, when they make an evaluation, are much more conservative. The figure is always a very conservative figure. But they said the Clean Power Plan, it would be at least $5 to $8 billion a year. The figures I've heard on that are far greater because it wouldn't be that much difference than the old system that they tried to do through legislation. The methane standards on oil and gas facilities, $350 million a year. The new ozone standards, $1.4 billion. The 2015 coal ash standards, $587 million a year. And the 2011 sulfur dioxide standards, $1.5 billion a year. Now, when you hear this, all this money is being spent for on compliance costs by our job creators, people out there that are working for a living and they're hiring people. What are your thoughts, and what do you believe should be the role of the cost of EPA's decision-making?
I think it's very important in the rulemaking process, Senator, and the Supreme Court and courts have recognized that very important factor. I mentioned earlier the case that we were involved in Oklahoma involving the Regional Haze Program. That was an example where Oklahoma actually complied and met and satisfied the requirements under the statute and the rule, but there are steps that were taken were displaced by the EPA, adding hundreds of millions of dollars of cost to consumers in the generation of electricity. And so costs are very important, and we need to make sure that that they're considered. In certain areas of the statute, as I indicated earlier, they can't be under Title I the NAAQS program. But in that case that you're referring to, it was an obligation of the EPA to actually engage in a cost-benefit analysis, make a record before it made its decision.
Yeah. Do you think that the laws that are on the books right now adequately handle this situation?
I do largely, Senator. I think it's mostly an application issue. Sure. The agency and the regulator doing its job under the statute is provided by Congress.
Mm-hmm. Thank you very much.
Senator Whitehouse.